but then argumentatively seeks to respond to the evident proposition that unless people were blindfolded or with their eyes closed, that's my flourish, not Mr Richter's, there were people in the space. Your Honours have seen how relatively small that space was, and you know about the stage in the processing or the breaking up of the processing that had been reached according to the complainant in this account. There were people in eyesight, in earshot. He was in the middle. Now, all this has to be extracted in cross-examination because the accountant-in-chief didn't condescend to it, but he's in the middle of people. How many people, we don't know, but more than the odd few. There is what I'll call an unsatisfactory instability to some aspects of the complainant's evidence, including about the second incident, to which, if I have time, I will return in compendious fashion later. But this is one of those points about which that is true. Those are also matters germane to the question whether what the jury saw and heard would be capable of resolving the reasonable doubt, put by the fact that apparently nobody saw it. Now, the circularity for the complainant is, with respect, in miniature, a reflection of a circularity in the respondent's argument, to which I'll be coming later. But the complainant says no one saw it because no one reported it, which of course is rather revealing of the nature of the activity in question. There are wisps of his evidence that Your Honours have read and heard and seen, where you might think that in this part of his cross-examination there might be the possibility of suggesting this was covert of a kind that could have occurred without anybody noticing. That might have been what was originally intended to be floated by the idea of the Archbishop being alone or on his own. It turns out that can't possibly be right in any realistic sense. It could at most convey... I didn't get the impression that it
was ever suggested as having been covert, was it? I thought the evidence was...
Your Honour is right, of course.
That it was in a corridor.
But with people, is what I'm saying.
No, I follow that. But there was no hint.
I'm simply saying one of the unsatisfactory aspects of the complainant's evidence that there are wisps of it that might be thought to have given rise to that possibility, which, as Your Honour correctly says, was squelched. That's out. It doesn't reflect well on the complainant, of course, and scarcely provides an explanation to this court as to how the jury, with the advantage they had, could have resolved the reasonable doubt concerning this kind of event that the complainant himself says, if seen, would be reported. Because that's how he reasons back. It wasn't reported, therefore it wasn't seen, even though he more or less accepts, in the passages we've drawn to attention, that it obviously occurred in a place where people could have seen it. Now, that in our submission is something which is very disturbing and very puzzling about that narrative. Those are epithets that inform any appreciation in an appellate bench of a reasonable doubt that a jury must have felt. How could you, hearing that narrative, seeing that grossly unsatisfactory way of responding to, in effect, wasn't this done in view of others? All of that, in our submission, produces the, I'll call it mandatory reasonable doubt, and not a shred of any circumstance in relation to the complainant's evidence or the evidence of the people we were able to ask questions about could explain how the jury would regard that reasonable doubt as having been dispelled.
Mr Walker, can I ask you, this prompts a more general question that I wanted to ask you. In the cross-examination at trial, and in the final address, but particularly in the cross-examination, it seemed to me to be being put to the complainant that he was inventing his story, that he was consciously...
I think fantasy was also... No, Your Honour is right, but fantasy is also put.
Well, that's the point of the question, really, because it seemed to me they're conceptually quite different.
They are. One can invent a fantasy. I understand bestsellers are made so, but...
no, let me just...
But they are different, yes.
you know, there's cross-examination about, well, you went back and read the transcript of the committal, didn't you? And you realised there were gaps in your story, didn't you?
Yes.
And you invented new bits of the story to fill the gaps. And
Yes.
as I read, the proposition being raised for the jury's consideration was that this was a purposeful liar.
That part of the cross-examination unmistakably does that.
Yes, and it does it repeatedly. I counted 4 or 5 occasions on which that line of attack was taken. Then, as you rightly point out, at a different stage, counsel puts, and this was what your client had said in, I think, the first interview, that this was fantasy.
The core account is fantasy.
This was something, an act of imagination. And it's also suggested, at least in the cross-examination or in the final address, that, and of course, you can be so convinced of your fantasy that you come to believe that it's true. You know, I dreamed that I was picked up by a flying saucer, and I dwell on this so long that I'm able to say to people, yes, it really happened. That, as I understood it, was the alternative proposition. My question for you is, does that matter? In other words, is it part of what the jury needed to think about in asking themselves whether they had a doubt to decide whether he was a purposeful liar or a naive fantasist?
It all matters in the sense that it is all to be considered. None of it is critical in the sense that without a particular outcome on a question that we're not allowed to know about because of the inscrutable verdict, there is no critical question, checklist fashion.
No. But doesn't it go to, or wasn't it directed at, in the trial, the jury's evaluation of the complainant's account?
Everything is grist to that mill.
Indeed. So
everything.
The primary proposition is, you're a purposeful liar, you went away and consciously thought about the problems in your confected account and you tried to fix them up and we've caught you. That being put, it seems to me that one, as a juror, would have asked the question, well, does this sound like an invented story?
Well, Your Honour,
Was that a question they might have asked themselves?
they might have, but if they thought that was the end of it,
No.
or this bench were to think that was a way in which the reasonable doubt thus raised could be resolved, then on their part, unreasonable error is introduced, and in this court, a misstep would be taken with respect to...
is not on trial.
Exactly. And unless grotesque reversal of onus were introduced, and it's not, then it's not for the accused to satisfy the jury of some nefarious or other telling explanation of the evidence of the complainant by which it would be utterly discredited.
But I'm carefully distinguishing between the imputing of a motive for fabrication, that wasn't done and didn't need to be done, and the imputation of fabrication, which was very clearly made repeatedly. I'm asking it because the points you've just made about the second incident might be thought to be inconsistent with invention. In other words, if you were going to invent a story, you would make it in secret, wouldn't you?
I do understand what Your
You
Honour
wouldn't
is
make
putting,
it
but
in an improbable place,
Yes.
in a corridor with other people around.
No, I do understand what Your Honour's putting, and there was no suggestion of the Crown, as it were, cross-examining the complainant on this. It can't be relevant so as to tell against us, either at trial or here, that full pursuit of the cunning behind a supposed invention didn't include just so what Your Honour has suggested. All of those are, with respect, the kind of speculations that will not permit the resolving of a reasonable doubt. If a reasonable doubt is raised, it can exist notwithstanding either having a view one way or the other about fantasy or invention, or not having a view about it, understanding that that's one of the possibilities, but not reaching a view about it. Because, as I tried to stress by my pinpointed reference in the High Court authorities, it goes without saying that the reasonable doubt for the appellate bench to see raised and to consider whether left is one which comfortably coexists, routinely coexists, with accepting that the jury saw and adjudicated after the complainant was challenged, and sometimes after the complainant and the accused both equally gave evidence and were challenged. That doesn't resolve the reasonable doubt, because whether there is significance in getting the wrong year, the wrong side of the holidays, the Archbishop not celebrating, etc., those are matters which, of their nature, raise reasonable doubt that the manner in which he resists or survives suggestions of confabulation really can't speak in terms of that. That doesn't remove the significance of those discrepancies.
No, but the key thing in a case like this, sorry to press the point,
I'm sorry, right? I'm sorry.
no, I was just saying the key thing in a case like this is to seek to raise a doubt about the truthfulness of what the complainant says, isn't it?
The cogency.
No, the truthfulness.
Is
this true? That's what the judge said to the jury.
Well, I'm trying to distinguish between the truthfulness, that is the honesty of a witness,
Yes.
and the state of being true as opposed to false of an account.
Just so. But if the imputation is that he's dishonest, which it was, then your predecessor wanted the jury to ask themselves that question in order to have a doubt. Isn't that right?
It's more than that, though.
No, it's at least that.
It certainly includes that.
So that's all I was getting clear.
Of course it certainly includes that.
And if I thought that the account given had none of the indications of invention, because an inventor would have made it much less improbable, that would be relevant, wouldn't it, to the question of whether the jury ought to have had a doubt?
No. It's only relevant in the sense that it is part of the whole of the material.
Yes.
It goes nowhere towards dispelling a raised reasonable doubt for this obvious reason. Picking up on Justice Weinberg's hurtful comment about lawyers, honest people do make mistakes. Honest people do get it wrong, and honest people can give accounts which are less than convincing. Honest people can give accounts which the hearer may think more likely than not to be true and truthful, but not beyond reasonable doubt.
But the primary
And that's
attack
my
was
point.
not that.
Oh,
It
no,
was not
you're-
said that he was honest but mistaken. The primary attack was that he was a devious, strategic...
No, Your Honour, no.
Well, I've read the cross-examination.
1432, lines 13 and following. The epithet primary is an inappropriate one. It was a multi-pronged answer, as you might expect.
All right,
And
well, whether it was primary or not, there was an attack which submitted that he was a liar.
Unquestionably, and my point is this, that for the jury, as they evidently did, they couldn't have convicted otherwise, to reject that attack does not carry with it what this court needs to examine as to whether the way he gave evidence could explain and resolve the reasonable doubt raised by being wrong in such particulars, bearing in mind that his evidence never included an explanation as to why that was so.
Thank you.
In Table K...
Sorry, Mr Rookwood. Really all you're saying is that the circumstances are such that it's inherently improbable that it could have occurred. It doesn't matter what...
No, you start with that, as the High Court has said time and time again. This is an incident that occurred in front of all these people, in view of all these people. It is, just as a matter of ordinary life observation, it's an unlikely thing to occur. Now, unlikely things happen, and they can include terrible crimes. We accept that. But, of course, that always tells what I can say in favour of an accused. It can never be put to one side.
I thought that's what I was...
I thought, Your Honour, the Chief Justice was asking me whether that, as it were, sufficed. And the answer is no, we've got so much more than that.
No.
I'm sorry. I'm sorry if I misunderstood. But is it important? Yes. Is it a starting point? Yes. Always. Now, Your Honours, where you have something improbable because of the picture we are asked to imagine, it becomes then significant with respect to reasonable doubt being raised that the jury should have felt to examine what the Crown did in terms of trying to respond to that inherent improbability. And the short answer is nothing.
This
So
is the
notwithstanding,
Father Egan point again.
it is. Not only that, it's more than Egan. By definition, there are other people. Now, we asked questions, but the Crown doesn't. And that, in our submission, is highly significant. The evidence from the complainant about this happening in front of people, with the ramification it has for the failure of the Crown to ask other people, did you see it? Is not mentioned in the Crown closing. Now, we then come, as Your Honour see in that table, to evidence, apparently credible, certainly not attacked, and certainly not the subject of any invitation to be disbelieved, from Monsignor Portelli. And you see our paraphrase with references at the top of the second page of the table, page 34. And he adds to the picture to be imagined what Your Honours know concerning the stature, physical stature of the Archbishop, which you may imagine compared with a choir including boys.
Do you say that if Monsignor Portelli's evidence was either accepted or reasonably capable of being accepted, that that's a complete answer to charge 2 and probably charge for the first incident as well?
Yes, I do. That is, it raises a reasonable doubt, and there is nothing, Your Honour knows the formula, there's nothing in the advantage, etc., which resolves that.
Well, again, I come back to what I said earlier, and I'll just stop at that point, but we're not in the position that the jury were in M's case, or that the appellate court was in M's case. We have seen or can see Portelli being questioned.
That's right.
And we're in the same position as the jury in relation to him.
Probably not the same position, but it must be very close, Your Honour.
What's the difference? What's the relevant difference?
It's only the difference between recording and Monsignor Portelli actually being present.
I'm at a loss to know what that means, Mr. Walker. Is
Your
there
Honour,
something about the body language, being able to see the body live rather than on a screen?
Your Honour, so am I with respect, because if trials are all recorded, there is a question that arises systemically as to whether that means the learning about the advantage the jury had has become stranded by technical change and no longer has any meaningful role
Or
to
has
play.
the same weight that it would have had?
I'm sorry, Your Honour.
Or has the same weight as it would have had at the time of M's case, the fact that the jury would have seen and heard the witness, whereas the appellate court does not?
That's right. Now, Your Honour's asked me about the difference, and I confess, because this is a new development, the notion of there being any difference in what I'll call abstract or general terms between viva voce, flesh and blood evidence, which is what the jury gets, and the court-organised recording of it, which appellate benches apparently can get is obviously very difficult to advance or justify in the abstract. It will depend upon things as pedestrian as camera angles and fidelity of recording, and I've got nothing to tell Your Honours about any of that in this case, and I doubt whether in many cases that will be of any significance. I mean, there will no doubt be, for recorded evidence, there will no doubt be similar cruces that have to be resolved from time to time, as we are all familiar with transcript, where there can be agreement on...
I can say that having seen some of the witnesses called, seeing them give evidence does provide an advantage. You can see in the case of one witness that I have a vivid recollection of, a shaking of the head emphatically before the answer is given. That adds to an advantage that the jury would have had, but I've got the same advantage, if I can put it that way, having seen it on the screen.
I entirely accept what Your Honour has said about the advantage Your Honour has. If you'll forgive me, all I'm saying, I can't point to anything specific in this case for any of the witnesses. All I'm saying is it may not be appropriate simply to say you have the same advantage. You have an advantage of a kind which may well mean that the special consideration given to what the jury does is either attenuated or transformed in a way which will be quite different from what was true at the time.
Your argument seems to be coming close to saying if we have a doubt ourselves on the material, given that we've seen, albeit through a television screen, these witnesses give evidence and so forth, then we don't ask the second limb of the M question or ask ourselves whether they had an advantage that we don't have, because one can't point to any significant advantage that the jury had.
I'm not so brave as to suggest a departure from the staged inquiry that the authorities require. What I put is this, that for that second stage, the procedure followed of Your Honours seeing the recording of viva voce evidence and seeing the same recording as the jury saw of recorded evidence is such that one would imagine the second step will come very close to being assimilated, because you will be able to say, and having had the advantage as appellate judge that I have now had through the recording of both kinds of evidence, I can either see or not see how it might be resolved by reference to how the jury had the benefit.
There are trials routinely conducted in Victoria now, retrials, where the jury never see a live witness.
No, quite so.
All they see is a television recording of the evidence given at the first trial.
As I say, I am at a loss to, will not spend any time trying to suggest that there is any difference apart from the difference of the personages involved. There's obviously a difference between appellate judges looking at a recording and a jury looking at a recording, but that's not a difference that matters, because that's in the nature of what you were doing as appellate judges. I entirely accept that in the now not infrequent phenomenon of a trial being had by recording played to a jury, as I repeat, it is quite beyond me. I am at a loss to put any substantive content to the difference between the advantage they had and you have.
But your point is that the law requires us to ask the second question, if we have a doubt,
Yes.
is that capable of being eliminated by such advantage as we think the jury had?
And in
And
answer
we should be sure to ask that question if we get to yes on the first stage.
And with respect, I accept what Justice Weinberg is asking me to respond to as a significant matter in this era, because the second step, as we're calling it, is in danger of becoming supererogatory or perfunctory if, in effect, the appellate judge says, yes, first step must have been a reasonable doubt, what I call raised. Second step, but hang on a moment, I can't now posit anything the jury had that I didn't have by way of so-called advantage, and therefore, of course, the answer is it's left.
An example might be, in this case, Monsignor Portelli's evidence about the cincture and how the cinch is tied.
Yes,
He demonstrates that
yes,
in the witness box.
yes,
So if there had been a doubt about possibility
yes,
that we as appellate judges felt ourselves in reading the transcript, because his actions are described for the purposes of this transcript,
quite.
that might be an example of where the
Yes.
jury might have had an advantage.
Which is-
However,
yes,
I viewed that, so I
Yes.
have seen it.
yes. Yes, Your Honour, I, with great respect, accept and adopt that, yes. That is an example.
Well, you're struggling as much as we're struggling with this new phenomenon and how it's to be applied through the two-stage process.
Yes, Your Honour, but I'm also trying to persuade Your Honours that it doesn't matter for my case.
Yes.
And that's why when I say I'm not brave enough to suggest the law is different, it's because I don't need to do that. And it is precisely with respect, as Justice Weinberg has raised with me, there's a real question as to whether the discrete and deliberate discreteness of what we're calling the first and second questions, whether that has the same meaning it had to have, bearing in mind the jury's status as the so-called constitutional tribunal of fact, bearing in mind the slowness with which the result of trial by jury should be disturbed by an appellate bench, etc., etc., etc. One is bound to say, well, all of that may require reconsideration in light of what I call fully recorded evidence.
But not by this court.
Certainly not in response to any argument I'm going to put.
Yes, thank you.
So I run the risk, which we submit is of no account whatever, of the second step being, as I say, supererogatory or perfunctory, but so much the better, because we say we would satisfy it by dint of having satisfied the first, in the sense that Justice Weinberg has asked me to consider. Now,
Yeah, and you say the evidence about what was or was probably going on is such as to raise, as it were, objectively.
yes,
When you put those pieces together, it doesn't turn on demeanour or,
No.
or
That's right.
actions in the witness box. It turns on what's on the record about what people did after Mass,
what is
relevantly.
exactly so, and how many people,
Yes,
and the striking nature, that is, if seen, would be reported, says the complainant.
just so.
The striking nature of what is done, and the image is of a fully robed, because he had been celebrating. Not what the Crown said to the jury or here, but that's what the complainant says, fully robed Archbishop in the middle of, etc. Now, can I come to another aspect which may enable me to abbreviate some matters this afternoon? The second incident, as Your Honours know, is an incident about which we were able to adduce some evidence from people who, if I can put it loosely, would very likely, to the point of virtual certainty, have been in the vicinity had any such thing ever occurred. And Your Honours have seen our reference to Mr Connor in that regard on page 34, the second page of the table. And in particular, he confirms that which Your Honours will now know from your now detailed understanding of the liturgical aspects of the procession after Mass, involved the priest who had celebrated accompanying the Archbishop who had presided back to the robing room, the sacristy. And so that raises, of course, by a method which is not capable of being eliminated by consideration of the so-called jury advantage, which really only means having seen and heard the recording of the complainant's evidence, same one as Your Honours have seen, that can't be removed by dint of that process of reasoning. And then that produces, of course, Father Egan with the matters concerning it, forensic disadvantage and the reasonable doubt raised by an obvious possible corroborator or contradictor not being investigated, upon which I opened. Your Honours will recall that one of the appropriately careful and ordered ways of a defence cross-examining to show the existence of reasonable doubt is to elicit from the investigating authorities, call it the detectives, the things that were done, the things that could have been done, and the things that have not been done, because it is obvious missing evidence in its nature conduces to reasonable doubt, and if sufficiently significant, may suffice to make it out. And in our submission, that is why a very short passage of cross-examination of Sergeant Reid with respect to Father Egan is of such significance. Now, another aspect of the circumstantial material by which the cogency of the complainant's evidence might fall to be considered for the second incident includes, of course, the nature of the procession. It had to be extracted from the complainant. The instability of evidence in this regard we may come back to later, compendiously, that this must have been an internal procession for the placement at the relevant time in the corridor to be possible. And the evidence was very strongly to the overall effect that internal processions were internal, that is, not going outside, depending on the weather. Now,
Did anyone produce any evidence as to what the weather was on that particular day?
Your Honour anticipates me, both as to the 15th and 22nd of December, which were where the alleged offending involved an external procession, because that's where they, to use the jargon, nicked off halfway down the external procession. And as to the 23rd of February, which the complainant accepts on his account has to be an internal procession, there were no weather records at all.
I'm sorry, there were no
There were none.
records.
There was no evidence about the weather. So it's only
So we
the
don't
inference that if there was an external procession, it's because it wasn't raining, and if there was an internal reference, it was because it was raining, but there was no evidence that whether or not it was raining on any of those dates.
Well, if it hadn't been raining, one would have expected the defence to call some evidence about that.
Yes, but we don't have
You don't have that onus.
We don't have an onus at all, and it's obviously not Weissensteiner, nowhere near Weissensteiner. And indeed, rather forensically, it is for the defence meeting a case where there is no shifting onus, where the onus remains throughout on the Crown, to point to gaps without always secure that no one will ever criticise the defence for not volunteering to fill the gap, either out of court by detective work or in court by calling witnesses or asking questions in cross-examination to invite information that had not been supplied in chief of the Crown witnesses. So there again, onus and the standard beyond reasonable doubt combine in a way that magnify the significance which accumulates in this case of the investigation and in the prosecution not calling material which may be able to say one way or the other, could a theory of internal procession survive an understanding of the splendour of the weather in Melbourne late February, 22 years ago. Is that a convenient time, Your Honours?
The President wishes to ask one
Just
question
before we
first.
adjourn, because I'm conscious that your time is limited, when we come back and when you're dealing with incident 1, I'd be assisted by your submissions on the point made in paragraph 48 of the Crown's submission about matters the complainant appears to have known and what the significance, if any, is of
Thank you, Your Honour.
that knowledge.
Yes, I would.
Thank you.
I hope Your Honours will forgive me. I would prefer not to deal with that immediately after the break.
No. I just
Yes.
wanted, at some point in
I
the
will,
afternoon,
yes.
it was just ready to alert you to it.
I'm obliged. Thank you, Your Honour.
Mr Walker, we'll be finishing at 4:15 today, and
Yes.
I think the allocated time for you was today.
Yes,
How are you going?
it will happen.
We thought that maybe it might assist if we came back at 2.
I'm very much obliged, Your Honours.
Adjourn the court till 2 p.m, please. Oh, just a moment before we adjourn. Sorry, remove the applicant, please. Adjourn the court, please.
Stand, please. This honourable court will resume sitting at 2 o'clock this afternoon.